Welcome back to LexTalks, Legal Topics Simplified, where we try to, simplify legal studies for students.
Yeah.
And today we're going to do a deep dive into a cornerstone of Indian property law.
Okay.
It's called the Rights and Liabilities of Parties, right of redemption and foreclosure or sale under the Transfer of Property Act, 1882.
Wow, that's a mouthful.
I know it's a mouthful, but trust me, it's a concept that you'll encounter throughout your legal career, so you really got to
Sure.
wrap your head around this one.
Yeah, this is one of those areas of law that touches so many aspects of life. I
Exactly.
mean, from home ownership to business transactions, even inheritance disputes.
Oh, yeah.
And, understanding the interplay of rights and liabilities is absolutely crucial in all those situations.
And we've got a ton of research to sift through today,
Yeah.
all from credible online sources
Okay.
to make sure we're giving you a well-rounded view
Yeah.
of this important area.
Yeah.
So are you ready to unpack this beast of an act?
Absolutely. Let's start with the basics. So the Transfer of Property Act of 1882 governs how property is transferred
Right.
between living persons in India, and it covers various types of transfers.
Mhm.
But today we're going to focus on mortgages.
I remember when I first encountered mortgages in law school, I thought,
Yeah.
okay, this seems pretty straightforward. Borrow money, pledge property, pay it back, or else.
Right.
But there's so much more to it than that, right?
Yeah, you hit the nail on the head.
Okay.
A mortgage isn't just a simple loan agreement.
Right.
It creates a complex web of rights and liabilities for both the borrower, known as the mortgagor, and the lender, called the mortgagee.
And that's where things get interesting and potentially tricky.
Oh, yeah.
Because if one party doesn't fulfill their obligations, it can have like a domino effect on the entire transaction.
Precisely. That's why Section 58 of the Act is so important.
Okay.
It lays down the legal framework for what constitutes a mortgage in India.
So what does Section 58 actually say?
Essentially, it defines a mortgage as the transfer of an interest in a specific property
Okay.
for the purpose of securing a loan or debt.
Okay.
And this transfer of interest is where things get a bit nuanced.
You're telling me, I remember scratching my head over that phrase for a while.
Mm.
What does it actually mean in practice?
Okay.
Does the lender, the mortgagee, become the owner of the property until the loan is paid off?
That's a common misconception,
Okay.
but it's not quite accurate.
Okay.
The mortgagee doesn't gain full ownership.
Right.
Instead, they gain certain rights over the property, including the right to potentially force a sale if the borrower defaults.
So it's more like they have a powerful claim on the property,
Exactly.
but not outright ownership.
Yeah, think of it this way.
Okay.
Imagine you have a valuable painting and you need a loan.
Okay.
You could mortgage the painting to a lender.
Mm.
The lender doesn't get to hang it on their wall and call it theirs.
Right.
But they do have the right to sell it if you don't repay the loan.
That's a great analogy.
Yeah.
Makes it much easier to grasp.
Good.
Now, the act itself doesn't use the terms borrower and lender, right?
Right.
It uses mortgagor and mortgagee.
Correct.
It might sound a bit formal, but those are the terms that you'll see in legal documents and court judgments.
Yeah.
It's important to be familiar with the proper terminology.
Absolutely.
Got it, like learning a new language,
It is.
the language of law.
It is.
Now, I'm curious about the different types of mortgages mentioned in the act.
Okay.
We briefly touched on this earlier, but can you elaborate?
Absolutely. So the Act distinguishes between several types of mortgages, such as simple mortgages,
Okay.
usufructuary mortgages.
Wait, usufructuary.
Yes.
Isn't that a fancy term for I get to use your stuff while you owe me money?
It is a fancy term,
Okay.
but you're essentially right.
Okay.
In a usufructuary mortgage, the mortgagee has the right to possess the property and enjoy its profits.
Right.
Think rent from a building or crops from a field to offset the interest on the loan.
So they're not just holding the property as security.
Correct.
They're actually getting something out of it while the loan is outstanding.
Exactly. This can be a win-win situation in some cases.
Yeah.
The mortgager gets the loan they need, and the mortgagee gets a stream of income
Right.
to offset the risk they're taking.
Makes sense. Now, I know the act also covers a ton of other scenarios related to mortgages, right?
Yes, it does.
Leases on mortgage, property, improvements made.
Yeah.
It seems like a lawyer's dream or maybe nightmare.
It definitely covers a lot of ground,
Okay.
but that's why it's so important.
Okay.
This act provides the framework for resolving all sorts of disputes that can arise in mortgage transactions.
Okay, so it's like the rule book
It is.
for the game of mortgages.
Yes.
We need to know the rules of the game before we can even start playing right.
Precisely. And understanding the specific rights and liabilities of each party
Right.
can be the difference between winning and losing, so to speak.
And that brings us to the heart of today's deep dive.
Okay.
The rights and liabilities of the mortgager and the mortgagee.
Okay.
But before we jump into those details, let's take a quick break. When we come back, we'll explore what happens when things go wrong.
Okay.
Who has the right to redeem the property, and what options does the lender have
Right.
if the loan isn't repaid? Stay tuned.
All right.
All right, we're back and ready to tackle the rights and liabilities of the parties involved in a mortgage.
Okay.
Let's start with the mortgagor, the borrower.
Right.
What are their key rights under the Transfer of Property Act?
Well, the most fundamental right of the mortgager is the right to redemption.
Okay.
This is enshrined in Section 60 of the Act.
Right.
And it's considered a cornerstone of mortgage law in India.
Right. Of redemption, that sounds almost poetic.
It does.
What does it actually mean for the borrower in practical terms?
It means that even after pledging their property as security for a loan, the mortgagor retains the right to get their property back free and clear once they've fulfilled their debt obligations.
So there's like a safety net built into the system.
Exactly.
Even if the borrower stumbles and misses a payment or two,
Yeah.
they still have the chance to reclaim their property as long as they eventually pay what they owe.
Exactly. The law recognizes that losing one's property can have devastating consequences.
Right.
So it provides this crucial safeguard.
Okay.
Of course, there are procedures involved, and it's not always a simple process, but the right itself is firmly established.
That's reassuring for borrowers.
It is.
Now, I'm curious about how this right has been upheld in real-world scenarios. Are there any landmark cases that illustrate its importance?
There are indeed. One notable example is the case of Santram v. Lob Singh,
Okay.
decided by the Supreme Court of India back in 1964.
Wow, way back.
In this case, the mortgage deed included a clause that attempted to restrict the mortgager's right to redemption if they didn't repay within a specific time frame.
So they were trying to pull a fast one
You could say,
and limit the borrower's options.
yeah,
But the Supreme Court stepped in
they did.
and struck down that clause,
They did.
emphasizing that the right to redemption is a fundamental right that cannot be unreasonably restricted.
That's right.
That's a major win for borrowers.
It is.
It shows that the courts take this right seriously
Yeah,
and are willing to protect it.
absolutely. This case set an important precedent
Right.
and reinforced the principle that the right to redemption is a cornerstone of a fair and just mortgage system.
Now, what if the mortgager, for whatever reason,
Yeah.
doesn't want the property back themselves?
Mm-hmm.
Can they transfer that right to redemption to someone else?
That's a great question. And yes, the Act allows for that possibility.
Okay.
Section 60A allows the mortgager, once they are eligible to redeem the property, to request that the property be transferred to a third party instead.
So they could essentially sell their right to redeem the property.
They could.
That adds a layer of flexibility to the whole process.
Precisely, it recognizes that circumstances can change,
Yeah.
and the mortgagor might not always be in a position to regain possession of the property themselves.
Now, let's say a borrower has mortgaged multiple properties to the same lender.
Okay.
Can they redeem those mortgages individually?
Yeah.
Or do they have to pay everything off at once?
The Act provides flexibility in that regard as well.
Okay.
Section 61 allows the mortgagor to redeem multiple mortgages, either all together or separately,
Yeah.
depending on their circumstances and financial capabilities.
Okay, so the Act seems to be quite borrower-friendly
It is.
in terms of providing options for redemption.
Yes.
Now, another right that I found intriguing is the right of inspection. What's that all about?
That's covered under Section 60B, and it's all about transparency.
Yeah.
This provision grants the mortgagor the right to examine documents related to the mortgaged property, such as title deeds, and even make copies.
So it's a safeguard against any hidden surprises or shady dealings.
It-
The borrower can make sure they're fully informed about the status of their property.
Exactly. Knowledge is power. And this right helps level the playing field
Yeah.
between the borrower and the lender.
Now, before we move on to the mortgagee's rights, I want to touch on one more aspect of the mortgager's position.
Okay.
Section 62. It talks about a usufructuary mortgager regaining possession under certain conditions.
Right.
Can you shed some light on that?
Of course, you'll recall that in a usufructuary mortgage, the mortgagee is in possession of the property and enjoys its profits to offset the interest on the loan.
Right.
Well, Section 62 lays out how the mortgager can regain possession, even in this scenario.
So it's like an exit strategy for the borrower, even when the lender is in control of the property.
Precisely. The mortgagor can regain possession if the mortgagee has fully recovered the mortgage money
Oh.
through the property's profits,
Oh,
or if there was a fixed term for repayment and that term has expired.
right.
The mortgagor can pay the remaining balance or even deposit it in court and get their property back.
That's interesting. It provides a way for the borrower to regain control even in a situation where they've ceded possession to the lender.
It does.
Now, this brings us to a crucial question.
Okay.
What happens if the mortgage property changes or something is added to it during the mortgage term?
Okay.
Like if a field suddenly gets bigger because a river shifts course,
Right.
or the mortgagee decides to renovate the house they're occupying.
Excellent question. You've just touched upon two key concepts,
Oh.
accession and improvements.
Okay.
These are covered under sections 63 and 63A of the Act.
Accession. It sounds like something out of a history textbook, like a king acquiring new territory.
Well, it's a similar concept in property law.
Okay.
Accession refers to additions to the property, whether by natural processes or human actions.
Okay.
Section 63 clarifies that any such additions generally belong to the mortgagor upon redemption.
So in our river changing course example, the borrower would get back a bigger field
That's right.
when they pay off the loan. That seems fair.
The law recognizes that these additions enhance the value of the property,
Right.
and the mortgagor should benefit from them.
Now, improvements
Yeah,
covered under Section 63A are a bit more nuanced.
they are.
Let's say the mortgagee, while in possession, decides to renovate the house,
Okay.
add a fancy new bathroom or something like that.
Right.
Generally, the mortgagor gets to keep those improvements upon redemption as well.
They do.
So they get a spruced up property back. Sounds like a win-win.
There is a catch, though.
Oh, what's that?
If those improvements were essential to protect the property from destruction
Okay.
or maintain its value as security, think urgent repairs to prevent further damage,
Yeah.
then the mortgagor would need to reimburse the mortgagee for those costs.
So it's about fairness and ensuring that the lender isn't unfairly burdened?
Precisely, the law strives to find a balance
Right.
between the rights and obligations of both parties.
Now, before we shift our focus to the mortgagee side of the equation, there's one more intriguing provision I wanted to explore. Section 64 deals with the renewal of leases on mortgaged property,
Okay.
and it seems to give the mortgager a unique advantage.
Right.
Can you explain that?
Absolutely. Section 64 states that if the mortgagee, while in possession of the property, renews a lease with a tenant,
Okay.
that benefit actually transfers to the mortgagor upon redemption.
So even though the mortgagee was the one who negotiated the lease renewal,
Yeah.
the mortgager gets to step into the landlord's shoes, so to speak, when they redeem the property.
The Act recognizes that even though the mortgagee might be in possession,
Right.
the ultimate ownership still rests with the mortgagor,
Okay.
and they shouldn't be disadvantaged by the mortgagee's actions regarding lease renewals.
That's a fascinating nuance.
It is.
It shows how the law tries to protect the mortgagor's interests, even when they're not in direct control of the property. Now, I think we've covered a lot of ground on the mortgagor's rights. Let's switch gears and explore what the mortgagee brings to the table.
Okay.
What are their key rights and obligations under the Act?
Well, the mortgagee's primary right, of course, is to get their money back.
Right.
And if the mortgagor defaults on the loan, the mortgagee has certain remedies available to them. The most significant one is the right to foreclose on the property or sell it to recover their dues.
Right.
This is outlined in Section 67 of the Act.
Right. Foreclosure. That's the big one we hear about in movies and TV shows.
Yeah.
It basically means the lender takes ownership of the property if the borrower can't pay upright.
That's the simplified version, yes.
Yeah.
But in reality, it's a more complex legal process.
Okay.
The mortgagee can't just seize the property
Right.
without following proper procedures.
Uh-huh.
There are rules and safeguards in place to protect the rights of both parties.
Of course, there's always a process.
There is.
Now, I imagine there are rules about what the mortgagee can and can't do while foreclosure proceedings are underway.
Absolutely. A landmark case, KS Dillon v. Punjab Financial Corp., decided in 2012,
Okay.
established a crucial principle. It ruled that once foreclosure proceedings have begun, the mortgagor is prohibited from transferring the property to someone else.
Ah, so no last-minute attempts to sell it off.
Exactly.
Before the mortgagee can take possession.
This prevents any attempts to undermine the foreclosure process
Right.
and ensures that the mortgagee's interests are protected.
Now, what if the mortgagee holds multiple mortgages on the same property?
Okay.
Can they initiate separate lawsuits for each one?
The Act addresses that scenario as well. Section 67A mandates that the mortgagee must file a single lawsuit if they hold multiple mortgages on the same property.
Okay.
This streamlines the process and prevents unnecessary litigation.
Efficient and logical, just what we expect from the law.
That's right.
Now, besides foreclosure, does the mortgagee have any other options for recovering their money?
Yes, they do. Section 68 grants them the right to sue the mortgagor directly for the outstanding amount.
Okay.
This is an alternative to foreclosure, and in some cases, it might be a more practical approach.
So they can choose to pursue the debt itself,
They
or
can.
rather than going through the complexities of taking possession and selling the property.
That's right.
That gives them some flexibility.
Exactly. The choice depends on the specific circumstances, the financial standing of the mortgagor,
Right.
and the mortgagee's overall strategy.
Okay, so far we've seen that the Act provides a relatively balanced framework
It does.
for both the mortgagor and the mortgagee.
Yes.
Now, there's one last section I wanted to delve into, Section 69.
Okay.
It outlines the mortgagee's power to sell the property.
Right.
What are the key points we need to know about this provision?
Section 69 is crucial because it lays out the rules for the mortgagee's power of sale.
Yeah.
If they choose to sell the property to recover their dues, they must adhere to certain guidelines. The most important one is that they must act in good faith
Okay.
and obtain the best possible price for the property.
So no fire sales or shady deals to benefit themselves
Exactly.
at the expense of the mortgagor.
That's right.
They have a fiduciary duty to maximize the sale proceeds.
Precisely, the law safeguards the interests of the mortgagor,
Right.
even in a situation where the property is being sold.
Right.
Remember, the mortgagee has certain rights, but they cannot abuse those rights for personal gain.
Now, all this talk about the mortgagor and the mortgagee makes it seem like a two-player game.
Right.
But there's a third player who sometimes enters the receiver.
Right.
Who is this mysterious figure?
The receiver. This is someone who can be appointed to manage the mortgaged property under certain circumstances.
Okay.
Usually when there's a dispute or a concern that the property might be mismanaged.
So they're like a referee making sure everyone plays by the rules.
That's a good analogy.
Okay.
Section 69A of the Act explains how a mortgagee can appoint a receiver. They have to follow certain procedures, and often court approval is required.
Okay, so it's not a step taken lightly. It's a significant legal move.
It is.
Now, what kind of powers does a receiver actually have?
They have a broad range of powers, all aimed at protecting the property and the interests of all parties involved.
Sure.
They can collect income from the property, pay taxes and other expenses, make necessary repairs,
Right.
and even arrange for insurance coverage.
Wow. It's like they're the temporary CEO of the property, making sure everything runs smoothly until the situation is resolved.
That's a good way to think about it.
Yeah.
They have a responsibility to act in the best interests of all parties involved and ultimately work towards resolving the debt situation.
All right.
They're not there to favor either the mortgagor or the mortgagee, but to ensure a fair and equitable outcome.
Okay. I'm starting to see how receivers play a crucial role in complex mortgage situations.
They do.
They bring a layer of oversight and accountability to the whole process.
Exactly. And while receivers might not always be necessary, it's important to know that the Act has provisions for their appointment when things get complicated or contentious.
This has been incredibly insightful.
Great.
We've covered so much ground today, from the basic definition of a mortgage to the intricacies of redemption, foreclosure, and the role of receivers. It's clear that the Transfer of Property Act of 1882 is a complex piece of legislation with far-reaching implications.
It is indeed, and it's a testament to the importance of property rights and the need for a robust legal framework to govern transactions involving such valuable assets.
Now, before we wrap up this deep dive, is there anything else our listeners, especially those aspiring legal eagles, should keep in mind as they delve deeper into the world of mortgages?
Here's a final thought to ponder. While the Transfer of Property Act provides a solid foundation, remember that the specifics of any mortgage agreement can be further tailored through contracts. The parties involved have the freedom to negotiate terms and conditions that go beyond the basic framework laid down by the Act.
So it's like the Act sets the default rules.
It does.
But the players can customize the game.
That's right.
To fit their specific needs and circumstances.
Exactly. And that's where things get really interesting for lawyers.
Okay.
Analyzing those specific contract terms, understanding their implications,
Right.
and spotting potential pitfalls, that's where your legal expertise comes in.
That's a challenge I'm sure our ambitious law students are eager to tackle.
I'm sure they are.
So much to learn, so many nuances to unravel.
This area of law is ripe for analysis and debate. The more you explore those nuances, the more prepared you'll be to navigate the complexities of real-world property transactions.
And that, my friends, is the essence of a good deep dive.
It is.
Thanks for joining us on this exploration of the Transfer of Property Act.
You're welcome.
And its impact on the rights and liabilities of parties involved in mortgages.
It's been a pleasure unraveling these legal complexities with you.
Don't forget to subscribe to LexTalks for more fascinating deep dives into the intricate world of law.
Please do.
Until next time, happy studying.
Thanks for tuning in.
All right, we're back and ready to dive a little deeper into the mortgagee's rights.
Okay.
Particularly when things don't go according to plan.
Right.
You mentioned earlier, expert speaker, that their primary right is to get their money back.
It is.
But what happens when the borrower defaults on the loan? What options does the mortgagee have?
Well, the Act provides the mortgagee with certain remedies to recover their dues.
Okay.
One of the most significant is the power of sale outlined in Section 69.
Okay.
This essentially means the mortgagee can sell the mortgage property to recover the outstanding loan amount.
So it's like a last resort for the lender?
Exactly.
When the borrower fails to repay the loan.
However, this power isn't absolute.
Okay.
The mortgagee can't simply sell the property on a whim. They have to adhere to certain legal procedures and act in good faith.
That makes sense. There needs to be a balance, right?
Absolutely.
Protecting the lender's interest while also ensuring that the borrower isn't treated unfairly.
The Act emphasizes that the mortgagee has a duty to act in good faith and obtain the best possible price for the property.
Right.
They can't just sell it off cheaply to a friend or family member, for example.
So no under-the-table deals
Right.
or attempts to shortchange the borrower.
Exactly.
They have to make a genuine effort to maximize the sale proceeds.
And the proceeds from the sale are then used to settle the outstanding loan amount.
Okay.
If there's any surplus left after covering the debt and any associated costs, it goes back to the mortgagor.
That's good to know.
Yeah.
So there's a mechanism to ensure that the borrower benefits if the property sells for more than the outstanding debt.
There is.
Now, we've talked a lot about the individual rights of the mortgagor and the mortgagee, but sometimes a third party comes into play.
Right.
The receiver.
Yeah.
You mentioned them briefly earlier, expert speaker.
I did.
Can you elaborate on their role?
Of course, the concept of a receiver is fascinating.
Yeah.
They're like a neutral third party appointed to manage the mortgage property when things get complicated.
Okay.
This could happen due to a dispute between the mortgagor and the mortgagee,
Uh-huh.
or if there's a concern that the property isn't being properly managed.
So they're like a referee,
That's a great way to put it.
making sure everything runs smoothly
Yes.
and that the property is protected.
They step in to ensure the interests of all parties are safeguarded.
Right.
Section 69A of the Act explains how a mortgagee can apply to have a receiver appointed.
I imagine it's not a simple process.
You're right.
There must be specific legal procedures involved.
It's not something that happens overnight. The mortgagee usually has to present a strong case to the court,
Yeah.
demonstrating why a receiver is necessary.
Okay, so it's a serious legal step,
Yeah.
not taken lightly.
Not at all.
Now, once a receiver is appointed, what kind of powers do they have?
They're granted a wide range of powers to effectively manage the property.
Okay.
They can collect rent or income generated by the property,
Uh-huh.
pay taxes and other expenses,
Right?
arrange for necessary repairs, and even ensure the property is adequately insured.
It sounds like they have a lot of responsibility.
They do.
It's like they're the temporary caretaker of the property,
That's a good analogy.
ensuring that it's maintained
Yes.
and protected.
They're essentially entrusted with ensuring the property is well maintained and its value is preserved during this potentially contentious period.
This has been a fascinating deep dive
Good.
into the Transfer of Property Act
It has.
and the intricate web of rights and liabilities it creates. We've covered so much ground, expert speaker,
We have.
and it's clear that this area of law is complex but crucial
It is.
for anyone dealing with property transactions.
Absolutely. The Act lays down the foundational principles for mortgages in India, aiming to balance the interests of both borrowers and lenders.
Right.
It's a testament to the importance of clear legal frameworks in protecting property rights and ensuring fairness in financial dealings.
And for our law student listeners,
Mhm.
I hope this deep dive has highlighted not only the complexity, but also the fascinating nuances of property law.
It's a dynamic field with real-world implications, and understanding these principles is essential for any aspiring legal professional.
So as we wrap up this episode, remember, LexTalks is here to make legal studies simpler for you.
We are.
Don't forget to subscribe and explore more with us.
Please do.
Until next time, keep those legal minds sharp.
It's been a pleasure joining you on this deep dive.
Thanks for tuning in.